that's not true.
Yes. Yes. And my plan is to get with Miss Andrea at Center for Healthcare Service, and explain to her my, issues that I've had personally, and see who she could get in touch with, like with the care team over there that I can follow through with.
Austin, if I could interrupt you, you met with somebody 2 weeks ago.
That my wife is all I have out there, and I understand that, what I did was wrong, but she's the only person I have.
So here's the thing. I understand what you're telling me, but what I'm telling you is based upon the allegations of your previous assault against her. You all agreed that the motion would be withdrawn, and this is from 2023, I believe. You agreed that it would be withdrawn and that there be no contact with her.
Please let me at least talk with her, because that's my daughter, that's my family. That's all I have.
No, in the letter that I received, she states in that letter that those are her biological children, not your biological children, that you have a biological child with someone else.
In the American legal system, a plea bargain is the foundation of case resolution. The prosecution and defense negotiate an outcome, which is then typically approved by a judge. But what happens when a defendant's history gives a judge pause? This case presents a fascinating look at the limits of such agreements. You are about to see a defendant accept a deal for violating his probation, but pay close attention to the moment the judge shifts her focus from the current violation to the defendant's entire case file. As you watch, ask yourself, is the final sentence a proper use of judicial discretion or an overreach based on past conduct?
So the last time we were here, on September 29th, he pled not true to violations 1 and 1. So is that still the case?
No, Your Honor. My client wishes to change his plea to true to both the allegations.
All right. So we're going to go on the record. The court is calling 2019 CR 8096 State versus Austin Zachary Mark Gibson. Could I have parties announced for the record for the state?
Lauren Espinoza.
Andrew Fraley to the defendant.
And are you Austin Zachary Mark Gibson?
Yes, Your Honor.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Austin Zachary Mark Gibson who was placed on deferred adjudication in 2019 CR 8096 for the offense of aggravated assault with a deadly weapon on February 21st, 2020 for a period of 7 years? Is that you?
Yes, Your Honor.
Deferred adjudication is a type of probation where, if completed successfully, the case is dismissed without a conviction. However, violating the terms, as alleged here, exposes the defendant to the full punishment range for the original crime.
All right, state.
Your Honor, violated condition number 1, on or about the 31st day of August 2025 in Bexar County, Texas, the defendant, Austin Zachary Mark Gibson, committed the offense of criminal trespass in violation of condition number 1.
How do you plead to that?
True.
Violated condition number 1, on or about the 31st day of August 2025 in Bexar County, Texas, the defendant, Austin Zachary Mark Gibson, committed the offense of criminal mischief greater than or equal to 750 less than 2,500 in violation of condition number 1.
How do you plead to that?
True, Your Honor.
Did you understand by pleading true to violations 1 and 1, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in the prison and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of conditions 1 and 1?
Yes.
Court will find violations of conditions 1 and 1 true. State, what are you recommending?
Your Honor, at this time, state is recommending that you grant state's motion to revoke, enter an adjudication of guilt, and sentence to 7 years in the prison.
This is the core of the plea bargain. In exchange for the defendant pleading true and saving the state the time and resources of a hearing, the prosecutor is recommending a 7-year sentence. Most of the time, judges will follow this recommendation to keep the judicial system moving efficiently.
And defense, what are you requesting?
Judge, we're requesting to continue. My client would like to address the court.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Austin Zachary Mark Gibson.
All right, so what do you wish to say to the court?
I just want to tell you that I do accept a full range of, full responsibility for it all, and I do apologize to you in the court, and the persons of that business. I did react like this due to, lack of consistency on my medications. I do ask that I can get the help, to get this correct. I have a meeting scheduled with Miss Amanda at CHDS.
I apologize. I'm going to ask a couple of questions and go back. Before we talk about Amanda from Center for Healthcare Services, talk about what happened. You said you were inconsistent on your medication.
Yes.
You want to be more specific?
A lot of the inconsistencies would be, getting up very early for work, like 3 a.m. I wouldn't, out, just pack my lunch and out the door. Being there's time that my phone isn't charged or plugged in, or even the noise, because my little girl would like to grab my phone.
And so you basically stopped taking medication.
Yes.
And ever since you got clean and sober, when did you get sober?
I've been sober for a good while.
Ever since you got out of Lifetime, pretty much?
Yes.
With one minor exception, but you've tested negative on your UAs since October of 2024. So basically for the last year, you've been all negative on all your UAs.
Yes.
And you successfully completed Lifetime Recovery inpatient.
Yes, sir.
Successfully completed SATF before that.
Yes.
You had done the outpatient program before.
Yes.
Completed your UAs in the last year successfully. Done private outpatient with Lifetime, is that correct?
Yes.
And you're behind on your fees though, is that correct?
Yes. But I do have employment.
Yeah, but go ahead.
I do have employment that I can catch that up. I did have a vehicle that had a lot of issues, and it took a lot of my money, and that's why I couldn't stay consistent on the payments. But this job that I do know is a second chance employer. They have accepted me for employment. So
here, the defense begins damage control and presents mitigating factors. Mitigating factors are details that don't excuse a crime, but might provide context to lessen the punishment. The defendant cites his inconsistent medication for his mental health issues, his successful completion of past treatment programs, and his efforts to maintain sobriety and employment. He is trying to frame this violation as a lapse caused by illness, not a willful disregard for the law.
And so since you got off your medication, that's the real problem you're having.
yes,
And what happened with this specific incident?
it was just time of day. It was hot. I just got frustrated. I outlashed towards just an inanimate object rather than a person, and broke the fence. And I was looking for water for my radiator because I thought it was the radiator that had failed, but it was the water pump. So I tried to put water into the reservoir so that it could feed back into the radiator, but I didn't find nothing but like maybe a quarter of a cup.
But what happened was you were trying to fix that.
Yeah, I wanted to fix that, and I couldn't find a water faucet that worked. So I said, oh, you know what? I already broke the fence. Let me go to the roof. Let me see if I can find a run valve for the HVAC system. Well, I found one. I tried to turn it, and it didn't work. So when I stood up, I slipped. And I kicked the piping right there.
And what does that have to do with you being off medication? Talk to the judge about that.
That's just, me. My mood swings have been, it's been a lot of up and down. And I never really understood how to talk to anybody about that. I would like to try to talk to my team there at the Center for Healthcare Service. But when I do call, a lot of the numbers, either when I call, they answer and hang up. Or, it sounds like a fax machine, like a beep, boop, beep, boop, boop.
I have a question.
Yes, sir.
You've been before me previously for a violation of condition number 1.
Yes.
And whenever there's a violation of condition number 1, that's a new charge. So what was your previous violation of condition number 1 for?
This is the critical turning point. Judge Boyd is now exercising her judicial discretion. She isn't just looking at the current violations, she's re-examining the defendant's entire history on her docket. She brings up a 2023 assault against his wife, showing a pattern of violent behavior. Her line of questioning indicates she is not convinced that the defendant's issues are being managed or that the community is safe with him on probation.
I can't recall.
All right. Could somebody look that up and tell me what that previous number one was? Because once you had a violation of condition number one for that time, the court denied the motion, and that's when you got sent to lifetime recovery. And the motion was withdrawn. So there was a previous number one. Yes, what was the previous number?
In 2023, the new offensive assault was withdrawn on 2023, and it was conditions were amended to include drug court, lifetime recovery.
All right. So that was an assault. And who was the complainant in that assault?
It was my wife,
The name?
Claudia. Russian.
Yes. And now I have a letter, defense exhibit number one, with her saying, there were some issues between you as far as you're not doing your medications.
Yes.
All right, continue. I'm just trying to get the sequence of events in my head.
Yes.
All right.
And it's just been there's not much else I could say about it. It's just, I've had a lot of, problems within myself trying to find either courage or, cry out. I'm not sure, but I didn't know that I could even come to you. A lot of people told me in the jail that I could ask you.
No,
for the
because
help
let me
too,
just
but-
tell you, let me stop you right there. You're saying that you can't come to me.
No.
I don't believe that. And let me tell you why I don't believe that. And your counsel will tell you this. Everyone in this court who is placed on probation, I let them know. If they have an issue, let their officer know. If they feel as their officer is not addressing it, then you can come back to me. And every time that somebody's had a motion to revoke, if I've continued them, I tell them that. So don't start with, I didn't know I could come, because that's not true.
Yes. Yes. And my plan is to get with Miss Andrea at Center for Healthcare Service, and explain to her my, issues that I've had personally, and see who she could get in touch with, like with the care team over there that I can follow through with.
Austin, if I could interrupt you, you met with somebody 2 weeks ago from Center for Healthcare Services since you've been in custody, is that correct?
Yes.
And when you met with her, she talked to you about if you're released, if the judge is kind enough to continue you can go to Center for Healthcare Services.
Yes.
And they will plan a treatment and a care team around you.
Yes.
That's what you told me.
Yes, they will.
So it's not so much of, you're going to talk to her when you get out, but you've actually met with her and.
Yes, and she's told me and 4 other gentlemen that they would do that.
And so what you're asking the court to do.
And I'm asking the court if you could kindly reinstate. If not, I accept full range of the punishment of my problems here.
All right. State, any questions?
Briefly, Your Honor. Mr. Gibson.
Yes.
At any point during this inconsistency you refer to, did you inform your probation officer?
Say again?
At any point during this time of inconsistency, did you inform your probation officer of that inconsistency?
It's been she's a very hard woman to get a hold of to start with. So, I mean, I would like to talk to her. Like I would want to tell her things like that, but she would always say like, no, that's not for me to deal with.
But my question is, did you make attempts?
Yes.
Okay. And then prior to August 31st, 2025, did you have contact with Center for Healthcare Services regarding this inconsistency? Or did you make attempts to?
Yes.
Yes. You mentioned that you were attempting to get water, correct?
Yes.
On or about August 31st, 2025, was the Wallace Bank open?
No.
Were there
I
other
don't think-
businesses around?
There was a Jason Sabdelli, I believe, but I had asked somebody like from the parking lot, like, hey, can you help me with some water? Just, they looked at me like I was crazy, so I was like, I'm not even gonna attempt to.
Would you agree with me when you jumped the fence for the Wallace Bank, you had 2 jugs of water with you?
No, I had an empty bottle.
So at no point you didn't pour water on yourself throughout the
I
time?
poured water on myself, yes, but it was that was very hot water.
So you would agree you came
Yeah,
to the Wallace Bank with
yes,
water?
with water, yes. But I needed more water.
Mr. Gibson, would you agree with me the best way for someone to learn a lesson about consequences for them to take full responsibility for their actions?
Yes.
No further questions.
Nothing further.
All right. So probation, on this case, can you tell me, was there any restitution that was due Vincent Arias and Victor Toro? All right. So, Mr. Gibson, what I can tell you is I read the letter from Miss Rushing. There is nothing else I can do to help you. And let me explain to you why. This is not your first motion to revoke. And each motion to revoke that you've had with me has been your having a new case. So the first time, you're, of course, on deferred adjudication for aggravated assault with a deadly weapon. And the first time was an assaultive case against, you say, your current wife. And that motion was withdrawn. I'm assuming it was withdrawn because maybe she didn't want to come forward, or maybe there wasn't enough evidence. I'm not saying either way. I'm just saying that with regards to that issue was addressed by withdrawing the motion. And when that motion was withdrawn, the first thing was a referral to felony drug court. And if you were not accepted there, a referral to lifetime recovery. And before that, you were sent to SATF. So there is, and then, well, actually, you've had more than one motion to revoke. So you had a motion to revoke in 2020. That was a violation of condition number 1. The court found that true after your plea of true. You were denied an alternate amended with a TAP evaluation follow recommendation. Then on November 2020, you're like, hey, I'm ready for treatment. Let me do it. And I said, okay. And that's when you were with your new wife, and there was supposed to be no harmful or injurious contact with her. And then after that happened, then there was a motion to revoke that was withdrawn, and they alternately amended conditions to include no contact with Claudia Rushing. And here we are with another number 1. And based upon the state's cross-examination and your answers, this wasn't about your seeking water. You had 2 jugs of water, and you actually poured water on yourself instead of pouring it in your vehicle. So, as previously stated, the court is finding 1 and 1 true. The court is going to find you guilty. The court will revoke you. There's an affirmative finding of deadly weapon. There's to be no residing in any household with minors.
Why is that?
There is to be no unsupervised contact with minors. And the court is going to have the previous conditions that were previously given. There's to be no contact with Claudia Rushing. Vincent Arias. And Victor Toro. I think it's Tovar, Tovar.
You're wrong.
And the court is going to sentence you to 10 years in the prison.
The judge delivers her sentence, and it's 3 years longer than the 7 years the prosecution recommended. This is a powerful demonstration that a judge is not a rubber stamp for a plea deal. She explicitly states, "There is nothing else I can do to help you," signaling that she believes rehabilitation has failed and incapacitation is now the primary goal. She also issues strict no-contact orders based on the danger she perceives.
The court will give you credit for any time served, credit for any time served for successful completion. Thank you. All right, if you'll let the clerks know. Successful completion of inpatient treatment. Court will recommend therapeutic community. Therapeutic community doesn't increase the time that you're in custody. It's just to provide you with help with your sobriety. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and sign it? All right, you do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are in deferred adjudication.
Quick question.
Sure.
That my wife is all I have out there, and I understand that, you know, what I did was wrong, but she's the only person I have.
So here's the thing. I understand what you're telling me, but what I'm telling you is based upon the allegations of your previous assault against her. You all agreed that the motion would be withdrawn, and this is from 2023, I believe. You agreed that it would be withdrawn and that there be no contact with her. So the court is following the previous condition.
Please let me at least talk with her, because that's my daughter, you know. That's my family. That's all I have.
No, she, in the letter that I received, she states in that letter that those are her biological children, not your biological children, that you have a biological child with someone else.
Oh, it's with her.
No, that's not what's in the letter.
With Claudia? Rushing? Yes, I have a little girl, Athena Gibson.
That's
with
not
her.
what she put in the letter.
Yes, I have a biological daughter with her, Your Honor.
Well, what I'm telling you is when you're released, you're not allowed to have any contact with her. When you're at the prison, you're not allowed to have any contact with her. You're not allowed to have any unsupervised contact with minors, and you're not allowed to reside in any home where there are minors. And that's based upon the letter that was presented to me. That's based upon your current actions.
And Judge, could we modify that to allow him to have contact with his biological daughter?
No unsupervised contact with minors.
The defense makes one final attempt to preserve a family connection, but the judge holds firm, reiterating no unsupervised contact with minors. She references a letter, likely from the defendant's wife, which details his behavior and its effect on the children. The judge's final decision prioritizes the safety of the children and the victim over the defendant's parental rights, closing the case with a clear, protective boundary.
All right, thank you. So sometimes you can only do what you can do to help people. And when people are placed on probation, your goal, once they're placed on probation, is for rehabilitation. And then at some point in time, there's nothing else that you can do. And many times when I do no residing in household with minors is because there are issues with him. Now, the letter that was presented to me to read, in that letter, she says he's off his medication. Sometimes he's violent. Then why is he living in a household with the children when he's not on his medications? And so that's a danger. And part of my duties is, yes, I can place people on probation, but if they're going to be on probation, I have to craft conditions that will protect the public. And many a time, for example, he's going to prison for aggravated assault with a deadly weapon. He has drug issues. He has, violent tendencies. There's going to be some woman in the world who's going to think he's a great catch, and they're not looking after their children. For example, his previous case where there was a new number one, that was involving the lady that he's saying, oh, I need to have contact with her. And in the letter I read, there was so much in there where he should not be having contact with her, but she's still making excuses for his behavior. And then when you have children who grow up around that, they think that that's normal. And so if they believe that the father, the mother loves their spouse, right? And they're being violent towards them, then they tend to think that's how you show you love somebody. So I do my part.
The court sentenced Austin Gibson to 10 years in prison. The judge's reasoning was clear. Despite multiple opportunities for rehabilitation, the defendant's pattern of behavior, including a prior assault and new violations, demonstrated that he remained a danger to the community and his own family. This case is a powerful example of judicial discretion and a judge's duty as a neutral arbiter. While the prosecutor recommended 7 years, the judge used her authority to impose a harsher sentence she felt was more appropriate, given the entire history of the case. Based on everything you saw, do you think the judge's 10-year sentence was fair, or was it too harsh? Comment down below with what you think.
Austin
All right,
Gibson
thank you.
stands before Judge Stephanie Boyd believing this hearing is
So,
about one bad day, one lapse in judgment,
Sometimes
one moment of
you can only do
frustration.
what you can do
He
to help
pleads
people.
true, accepts
And
responsibility,
when
and
people are
listens
placed
as
on
the state
probation, your
recommends 7
goal,
years in
once they're
prison.
placed on probation,
For a
is for
moment, it
rehabilitation.
feels like the system
And
will
then
move
at some
on,
point in
just as
time,
it
there's
usually
nothing else
does.
that you can do.
But Judge Boyd
And
does not
many
stop at the
times
surface.
when I do no
She
residing
begins
with
tracing
in
the
household
pattern.
with minors
A
is
deferred
because
adjudication for
there are
aggravated
issues with
assault.
him. Now, the
A
letter that
prior
was
assault
presented
against
to
his
me
wife.
to read,
Motions
in
to
that
revoke
letter,
that were
she
withdrawn.
says he's off his
Treatment
medication.
programs offered.
Sometimes
Drug
he's violent.
court.
Then why is he
Lifetime
living in a
recovery.
household with the children
Again and
when
again,
he's not
opportunities
on
were
his
given,
medications? And
conditions
so that's a
adjusted,
danger.
warnings clearly
And part
stated.
of my duties
Gibson explains missed
is,
medication,
yes, I can
mental
place
health
people on
struggles,
probation,
and
but
a
if they're going to
desire
be
to
on
do better.
probation, I
He
have
describes
to
sobriety,
craft
employment,
conditions
and plans
that
for
will protect the
treatment.
public.
Yet as he
And
speaks,
many
the
a
judge
time,
presses
for
harder,
example,
exposing
he's going to prison
contradictions.
for aggravated assault with
The
a deadly
incident was
weapon.
not
He has
desperation for
drug
water.
issues. He has,
He had
you know,
water. He
violent
poured it on
tendencies.
himself.
There's
The
going to
story no
be
longer holds.
some woman in the
Then
world
comes
who's
the
going to
letter.
think he's a great catch.
A wife
And
describing
they're not
fear,
looking after their children.
instability, violence,
For
and children
example,
living
his
inside that
previous
chaos.
case where
The
there was a
courtroom
new number
shifts.
one, that was
This is no
involving
longer about punishment
the
alone.
lady
It
that
is
he's
about
saying, oh, I need
protection.
to have contact with her.
Judge Boyd makes it
And in the
clear,
letter I read,
rehabilitation has been
there
tried
was
repeatedly
so
and
much in
failed.
there where he
The
should not
risk
be having
remains.
contact with her. But
She
she's
rejects the
still
plea recommendation and
making
imposes 10 years
excuses
instead.
for his behavior.
No
And
contact
then when
orders
you have
follow.
children who grow up
No
around that,
unsupervised
they
contact
think
with
that
minors.
that's normal.
No
And
exceptions.
so if
Each
they
ruling
believe
lands
that the
heavier than the
father, the mother
last.
loves their spouse, right?
Gibson pleads for family,
And
for
they're
one
being
last
violent
connection,
towards them,
but the answer
then they
does
tend
not
to think that's
change.
how you show you love somebody.
In the end, the judge
So
explains her
I
duty
do my
plainly.
part.
When
The
patterns
court sentenced
persist,
Austin
compassion
Gibson
must
to
yield
10
to
years
safety.
in prison. The judge's
The
reasoning
sentence is
was
not
clear.
about one
Despite
mistake,
multiple
it is about all of them
opportunities for
together.
rehabilitation,
And
the
that is the
defendant's
moment
pattern
his
of
last
behavior,
hope finally
including a
disappears.
prior assault and